The House Judiciary Committee will come to order. Madam Clerk, please call the roll.
Chair Breen.
Present.
Representatives Edwards.
Here.
Carter.
Present.
Hope. Here. Arbit.
Here.
Devendorf.
Here.
Hoskins.
Here.
Cerniglu.
Here.
Fink.
Here.
Wenzel. Wozniak.
Here.
Outman.
Here.
Johnson.
Here.
Madam Chair, you have 12 members present. You do have a quorum.
Thank you, Madam Clerk. I will now take a motion from Representative Edwards to approve and adopt the minutes from the previous meeting. And those are now approved. We do have everybody present, either here or remotely. We are not going to be voting on any bills today. What we will be doing is hearing additional testimony on House Bills 4909 to 4912, as well as 5047. But before we do that, we'll be taking testimony on Senate Bill 248. And I see we've got a pretty packed courtroom, and I want to tell everyone, again, we are not taking any votes today. And unfortunately, we have a hard stop. So if I cannot get to you, unfortunately, I'm not going to be able to go over. And if you're here to testify about guardianship, we do have your cards that have been submitted. Again, I will try to get to folks, but for the people who have been scheduled to speak, but they couldn't last week because of time, I'm going to ask them to keep their testimony to no more than 5 minutes. To anybody testifying on Zoom, I'm going to ask them to keep it to no more than 5 minutes. If we have time, we will get to everyone. If not, I absolutely welcome people to submit a card, to email the clerk so that your testimony can be included in the written record with the minutes. And we will hopefully be taking votes on the guardianship bills next week, and there would be another opportunity then. So with that, I would like to welcome a representative from Senator Lauer's office. We have Josh. I am not going to try to pronounce your last name. There's a lot of consonants here. What is your name, sir?
Josh
Scripcheck.
Scripcheck.
There we go.
Close enough.
Okay, thank you. Here to give us some background and information on Senate Bill 248.
Yep. Thank you, Chair Breen, committee members, for taking this legislation up for consideration. This bill would enable victims of certain crimes, such as child sexual assault or abuse, who are under the age of 18 and are called upon to testify, to have a courtroom support dog accompany them during their testimony. Current law provides this accommodation to victims who are under 16 years of age. Testifying in court can be a challenging experience, but it can be particularly difficult for young victims of abuse or sexual assault. Extending the use of courtroom support dogs to victims under 18, an age group that is still developing cognitively and emotionally, will allow more young victims of these crimes to access the support they need to participate in the legal process. As written, the bill would allow the continued use of therapy dogs so long as approval is given by the chief judge or presiding judge of the court. More and more therapy dogs that have been in use prior to September 2018 are aging out of service, have passed away, or will soon do so. Once the last of these dogs passes away, courts will be limited to using only dogs that are trained pursuant to the Assistance Dogs International Standards. We were made aware of some concerns from one organization just yesterday about specifying a level of training or certification that therapy dogs must complete. We do have that amendment, but we'll be, given the late notice, we'll hold off on that. But we were able to work with them on some clarifying language that would have them meet the American Kennel Club certification. And then I do have someone remotely joining me with West Michigan Therapy Dogs, Inc. She's not, okay. I'll turn it over to you then.
Good morning, and I appreciate the opportunity to address all of you. My name is Courtney Carl, and I'm the St. Clair County Victims' Rights Coordinator, as well as the Canine Advocate Coordinator for Care House in Oakland County. I have been doing advocacy work for going on a decade now, and I have had 2 dogs in my office that have been able to assist child victims. And one thing I did want to bring up to you as we propose this bill and raising the age as well as the dogs, it is important to take into consideration the handlers as well, as it is very tough to sit next to a child and hear them talk about their sexual abuse in front of the jury. And it is important that you have somebody trauma-informed, trauma-trained with them so that the jurors are watching every move that they make. And if they are of some sort of emotion, you know, we are trying to prevent any mistrial or appeals issues. So I do think that it is important that we take into consideration the standards of these dogs that we will be allowing to testify with these kids. So I thank you, and I appreciate any questions or anything that you may have.
I just want to clarify these are for dogs only, no other support animals?
Correct.
Correct.
Okay, so nobody's going to come in with like a pet alligator. You're not trying to do anything like that?
I hope not.
Because that is a true story.
I would not be in the courtroom if
Okay.
somebody tried to come in.
And the dogs, they are part of the court system, or they are dogs that people bring in as their own support animals?
These are provided by, usually a court will partner with an organization, and then the organization will do all the training of the dogs and their owners, and then they will work with the courts.
Okay.
That's what I'm currently doing now with the Canine Advocate Program with Care House in Oakland County, is training the dogs placed with prosecutors' offices, the dog and the handler.
Okay. And Courtney, you're from Canine Advocates?
Yes.
Okay. We have a card from somebody else from your organization?
Yep.
Okay.
Ian Kojin.
And do we have the person on Zoom yet?
He is here in the courtroom.
No, the Paula Nelson. She was supposed to testify via Zoom. Okay. If we don't see her in the next minute or two, then
Yeah.
she's welcome to
That's
try
fine.
to
Yep, that's
testify
fine.
next week. Yep. Representative Edwards?
I just had a really quick clarifying question. So if the person already has a dog trained in trauma and able to be their support dog, would they be able to use that dog, or do they have to use the court-appointed dog?
It would be, I believe it would be court-appointed dogs, but I can get back to you on that just to be sure. But basically, there are organizations throughout the state that are AKC therapy dog certified organizations, and they meet the AKC's standards, and then so that way there's a little bit more comfort there in terms of where these dogs are coming from, and not, yeah, my dog's trained, can it come? I think it's, you have to go through an organization, but I can get back to you on
But
that.
if their
with you.
dog has possibly went through that organization, they could utilize that dog too, right?
Yeah, yeah.
Okay, thank you.
Representative Hope?
Thank you. Thank you for this legislation. I understand the importance of animals and how they can really help someone who's been traumatized. I have an unserious question, kind of in the same vein as committee chair has made the suggestion multiple times that we need therapy dogs on the House floor. No dog should be subjected to that ever.
That was my suggestion,
I
and
just
I
said
was
that.
serious.
You're not listening. Yeah, I just said that.
I'm not kidding. We
Yeah,
could.
but I do feel a little shortchanged that we don't have any dogs here today.
Representative Fink?
Thank you, Madam Chair. So you mentioned the possibility of creating a mistrial or of that being a claim here. Could you just say a little bit more about it? I mean, I understand the question to be, and I mean, this comes up in other contexts in which we're trying to take a step to elicit testimony from victims or potential victims or alleged victims. Could you just say a little bit more about what steps are taken to prevent the? My assumption is what you're referring to there is sort of sympathy driving the decision of the jury rather than the presentation of the case. So could you just say a little more about what those steps are like?
Right, so jurors are given a jury instruction now that they are to ignore the dog, not pay attention to the dog. Jurors aren't aware of why the dog is there. They could think that the dog is there for my support or whatever. So they're given that instruction before and after, at least in my county. But my concern is more with the handler of the dog. If they are not somebody that is used to hearing these things in open court and everything, where we are sitting, we are in the witness box with that child. So if the juror, which you want them to be looking at your child that's testifying, that they're looking at you as well, that if you are showing emotion or given any reaction, that a jury could potentially view that, and as well as the defense attorney, right? They're going to jump right on that. So we try to limit that as much as possible so that we only have to ask the child to do this once.
Thank you. Representative Arbit?
Thank you, Madam Chair, and thank you, Senator Lauer's team for being here and for this legislation. When I served at the Oakland County Prosecutor's Office, I became well acquainted with the CAP program, and our two canine advocates, Lance and Frida, in the office, and actually my constituent Dan Kochnu was the founder of the program. And I'm just wondering, we have seen really remarkable results and efficacy of use of canine advocates in different courtroom settings, and I'm wondering what the reasoning behind, or if there has been any work done to try to look at whether or not it might be worth expanding to. I mean, why are we limiting this just to children, right? And especially because between they say that your brain doesn't stop developing until you hit 25 years old, and so I feel that we are leaving a huge age gap. I mean, I can speak from personal experience about having to testify as a victim when I was just above my 18th birthday, of 18 and 3 or 4 months. So I'm just wondering if there is any to perhaps expand the legislation.
Yep, thank you, Representative. I think that's certainly a conversation worth having. I believe Senator Lauers would prefer that to be done outside of this legislation. I personally would also want to kind of take a deeper dive into and hear from other people who work in the judiciary to see what kind of impact that would have on them from the court system, staff. But no, I definitely think that's a conversation worth having.
Representative Johnson?
Thank you, Madam Chair. Just a quick question. How does it present itself? Because we also know that some children are afraid of dogs. Some children have allergies to dogs. So how do you present that and then figure out they use a dog, they don't use a dog, and how that goes down?
That starts with the initial contact that we make with the child's family when we make that first initial phone call to them. Are they okay with dogs? Do they prefer dogs? And then if they say no, absolutely not, then the dog's never even introduced to them. If they are more welcoming to it, then we do a slow introduction, usually before the first court hearing, so that they can, one, get to know the dog, but me as well, because I will be there and they will have to testify in front of me as well as the prosecutor. So it's a slow introduction process, but we always ask before introducing the dog to anyone.
All right, thank you. I'd like to now turn to Paula Nelson on Zoom, please. Hi, Paula.
Can you hear me?
Yes, I'm hoping that you can limit your testimony to about 3 minutes.
Okay, I certainly can. I just want to respond to a couple of things that were said. One of the things that we do during training is we really focus on the fact that when you're working with a therapy dog, it's all about the dog and the person the therapy dog is interacting with. It's not about you as a handler. So we're the person on the end of the leash to keep the dog doing what it needs to be doing, but we are not part of the interaction that goes on between the victim in the courthouse and the dog itself. So oftentimes our handler sits on the floor in the jury box so that they just can have a hand on their dog that might be sitting in a chair or standing in the jury box next to the witness. But the focus is not about us. Some of the other things we've done is the judges have allowed the handlers to wear AirPods or headphones so that they have conflicting information going in. So they're not listening. They're not focusing on what the child is saying. What the child is saying is not the reason we're there. We're there to be in tune with the dog and the dog's interaction with the child.
Thank you. Are there any questions for Ms. Nelson? Okay. Thank you for your testimony. My office will be in touch to see whether or not we're going to do something with this next week, but we'll let you know. And I'd like to call up Dan Kochnu. I'm sorry if I didn't say that right.
You said it right. I'd be suspicious, so thank you. Good morning, committee members. Thank you for letting me speak today. I will be brief. I'm a co-founder and newly retired program director of the Canine Advocates Program. I developed the program 13 years ago I have 46 years of experience working with neglect and abused children, and I just want to offer my input on this bill. As Courtney indicated, the biggest concern is not having handlers with the proper training to be in it. Our program requires that anybody going into a courtroom with a dog be a victim advocate or involved in the system. We have one place with a sheriff investigator, and they have to have this. I don't know that, it's very hard to conceive of sitting with a child who's talking about being sexually assaulted and not showing some emotion. And again, the mistrial is a big issue. I've talked to some of my defense attorney friends, and they said they would be all over this if somebody started crying or reacted in any way. And if you react, that goes right through the leash to your dog. Your dog is probably going to act out too. That will disrupt the court proceedings, and that cannot happen because we have just re-victimized that child. We're saying, okay, mistrial, you got to come back and do this again. That is not acceptable. I'm sorry, I get a little. Our canine advocates all come from Leader Dogs for the Blind. With their career changed, they are evaluated by Leader Dog, re-evaluated by an independent evaluator to make sure they have the proper temperament, low drive, and are appropriate for the program before they're even considered being placed. We know their history from day one. We know if there's been obviously any aggressive tendencies. We know everything about that dog, so to make it as safe as possible for these kids. And I like therapy dog programs. I referred a number of people to Therapy Dogs International to work, but they don't have these kind of things in place to make sure that that child is going to be safe. I'm very supportive of raising the age to 18. Noah, if you're listening, I'm with you. I don't think there should be any age, or it should be 106. I think everybody should have access to a dog, because saying that a victim of sexual assault at 23 doesn't need a dog, I think is ludicrous. But again, that's another issue. Child advocacy centers are very supportive of the raising age. They've talked to me about this, where they'll have a child that comes in at 15, they hit 16, all of a sudden they can't have a dog in court. So raising it to 18, very supportive of. I just want to thank you for this opportunity to come here today. I think we all share the same goal. We want kids to navigate the system without, we need to do less harm. We expect these children to testify like an adult. And this program lets them, it gives them a little filter. And with that filter, I think we need to be sure that these kids are safe and that they're not going to have to come back again because of a mistrial or anything. We need experienced people in that box with that child. And I volunteer myself, and I think I'll volunteer Courtney if there's anybody who needs our input. Because if we have a seat at the table, this bill can work, and it'll still keep kids safe and give them the support.
Sure. Thank you for your testimony today. And does anybody have a question? Representative Johnson?
Just a quick one. Are trials delayed ever if, or maybe someone else answers it? I wouldn't want a trial delayed just because we don't have enough dogs, but is that how it would work, or how does that work?
We have plenty of dogs. I was a little concerned to see that all of our dogs are aging out. When our dogs retire, we have one usually waiting within a few months. We do not have a shortage of dogs. We also have a dog share program. If somebody in one county says, yeah, we need a canine advocate, all they have to do is call a surrounding county, and the advocate and the dog will be there. Everybody loves to show off their dogs, so they're more than willing to travel to help out somebody. So there is no shortage of properly trained, career change dogs from Leader Dogs for the Blind.
Thank you. Representative Fink, did you have a question?
Yeah, just a very quick clarification. You mentioned sexual assault prosecutions,
Yes.
but this would apply for other assaultive crimes as well, right?
Oh, yeah, absolutely. With neglect, abuse, any type of assaultive crime. 95% of our cases are child sexual assault that we deal with.
And as you, right, that makes sense. And as you spoke about screening the animals themselves, are you aware of any incidents where the animal has acted out in a way that was a problem for the victim?
No.
Yeah. Okay.
I personally have trained 45 of our dogs, and we make sure a dog will lay down in the box, and no matter what the distraction, I yell into microphones, I throw chairs, I slam books, that dog has to stay in a down position, cannot move. So we know that that dog is well trained. We've never had an incident.
Thank you.
Thank you for your testimony, sir. I'd like to talk to you about this bill further after this hearing. With that, I'm going to have to change gears, but thank you again for coming.
Thank you. You want me to
And-
stick around?
And also, I'm going to read some cards in supporting the bill. Not wishing to speak, Nathan Triplett from the State Bar of Michigan. Supporting the bill, not wishing to speak, Heath Lowry from the Michigan Coalition to End Domestic and Sexual Violence. Supporting the bill as amended, which we're going to be working on, Brandon Lenyon from Prosecuting Attorneys Association of Michigan. And what? Yeah. Okay. Oh, Michigan Humane Society support, not wishing to speak. And Monica Martinez from the Michigan Judges Association supporting the bill, not wishing to speak. And Attorneys for Animals supporting the bill, not wishing to speak. That is Beatrice Friedlander. And the State Bar of Michigan Animal Law Section supporting the bill, not wishing to speak. Thank you so much. We're going to switch gears now, and I am going to call up Nicole Shannon from the Michigan Elder Justice Initiative to talk about the guardianship bills. Do you want to bring your partner in guardianship, Allison, up at the same time?
Yeah, I don't know. We also have other colleagues.
And Allison Herschel, also from the Michigan Elder Justice Initiative. All right, ladies, take it away.
Sure. Well, good morning again. Thank you for having me back, Chair Breen and members of the committee. By way of brief reintroduction, my name is Nicole Shannon. I'm an attorney with the Michigan Elder Justice Initiative, and I am a member of the Elder Abuse Task Force. When I was here a few weeks ago, I shared 4 stories about real Michiganders who are impacted by the EPIC adult guardianship system, and I'm here today to tell you that these are just the stories that happen to make the news. There are countless other similar stories from the approximately 60,000 Michiganders who are subject to EPIC adult guardianship. I am proud to handle these cases myself, but I'm also proud to provide support to legal services lawyers across the state who handle these cases every single day. And those of us in the field know that we are not asking for too much in these bills because we know it is possible. And we also know that what we are asking for is necessary because we've seen the devastating consequences of the status quo. And I say we know it's possible because there are already courts, guardians ad litem, and attorneys that are voluntarily doing the key things proposed in these bills. Just after my testimony, I spoke with a few members of the Michigan Guardianship Association who already live by the spirit of these proposals. And that means forging personal relationships with those who they serve, ensuring that decisions are made to maximize independence and autonomy, and occasionally calling on me or a colleague to terminate or modify a guardianship on behalf of their clients when it's necessary. During my time on the task force, I was also proud to develop these proposals alongside the then president of the Michigan Probate Judges Association, who is integral in ensuring that any court reforms would be realistic because they are things that many courts already do. Unfortunately, not every guardian handles things the way that those MGA members who I've spoken to handle their work, and some wouldn't be able to pick their clients out of a lineup. Not every court is delivering due process in the way that the previous president of the Michigan Probate Judges Association does, and some decisions are made with very low quality evidence and without the individual subject to the petition even present. We know a better future is realistic. We know it is possible because the practices in these bills are already happening in some bright pockets of the system. These changes are reasonable, they are practical, but most importantly, they are life-changing. And I say life-changing because the status quo cannot stand. Hearings without the individual at the heart of the case, inconsistent guardian ad litem practice, contested hearings that take less time than a pizza delivery, guardians who have no personal relationship with those who they serve, and a highway with no off-ramp are not acceptable. And for some, the status quo is very comfortable, and change can be hard, but it's also necessary. We know the sky has not fallen in the states that have implemented similar changes, and instead those states have become more just, protecting independence, autonomy, dignity, and due process for all. Thank you. I'll turn it over to my colleagues.
Thank you. I'm Allison Herschel. I'm the Director and Managing Attorney of the Michigan Elder Justice Initiative. Very proud to work with my colleague Nicole. 4.5 years ago, I was appointed by Attorney General Nessel to serve on the Elder Abuse Task Force, and I've been privileged to be at the heart of many of the deliberations of that task force since then. I'm also a former commissioner of the ABA Commission on Law and Aging. I was a delegate at the most recent National Guardianship Summit, and I'm a longtime adjunct faculty member at the University of Michigan Law School. For my entire 38-year legal aid career, I've been concerned about my clients and others like them who are caught in the guardianship system. The Elder Abuse Task Force proposals before you today address the most pressing concerns that we have uncovered in that system, and some of which Nicole just referred to. As Scott Teeter noted last week, 25 years ago, the Michigan Supreme Court Task Force on Guardianship and Conservatorship addressed many of these same issues. That task force was led by an esteemed probate court judge, and that task force was comprised of a diverse group of stakeholders, much like the group that has been working with the Elder Abuse Task Force now. The recommendations sought to reduce the number of guardians appointed, protect individuals under guardianship from abuse, and promote as much independence as possible for those subject to guardianship. And many of those recommendations have the identical goals of the legislation before you today. It just took a really long time to get here. While some of the proposals in the bill package reflect new approaches, some of the issues addressed in the bill package are already reflected in current law, but they're too often ignored in practice. Therefore, some of the proposals are simply additional tweaks to ensure that the long-standing intent of the law is finally realized. Although each state guardianship system is different, states across the country have faced the same challenges we face, balancing individual rights on the one hand and the practical realities of busy courts and limited resources. The American Bar Association, the U.S. Senate Aging Committee, the U.S. Government Accountability Office, the Department of Justice, and a host of other esteemed organizations have called for additional protections for respondents in the guardianship system. And the proposals before you today are entirely in line with the best thinking on guardianship across the country and what many states have already adopted. For example, at least 14 states already have an Office of a State Guardian. And let me correct that. At least 14 states already have certification or licensure requirements for professional guardians. A number of states have long required court approval to change the residence of the individual subject to guardianship. Many states have extensive requirements for the guardian ad litem and court visitors. In 2017, the Uniform Law Commission created a model guardianship and conservatorship law. The proposals before you incorporate many of the best thoughts in that model law because Nicole and I and many other members of the task force carried that thick model law around for months as we were drafting these proposals. The 2021 recommendations of the National Guardianship Summit also address the goals of maximizing individual autonomy and ensuring accountability. Some of their recommendations mirror the task force's work, especially related to the creation of the Office of the State Guardian. But I have to say, to be frank, that our proposals are more modest than many of the recommendations of the National Guardianship Summit, because our proposals reflect years of negotiation and compromise and discussion to make sure that we have a package that will work and that can be acceptable to stakeholders across the state. If we look at developments in other states, we see a variety of innovations that address the same problems we're trying to solve. In many of those states, probably in all of them, there was resistance to change by a range of stakeholders. Advocates in those states thought the proposals didn't go far enough. Judges, lawyers, and other stakeholders were resistant to change and really committed to the status quo. But at a recent National Adult Protective Services conference, representatives from many states shared their guardianship journeys, guardianship reform journeys. And what I heard again and again, and what was reinforced to me just this week by two very prominent national advocates, is that despite the fears and resistance to those proposals in other states, as Nicole said, the sky did not fall when the reforms were implemented. Stakeholders got used to the new measures, systems improved, and individuals at risk of or under guardianship had better outcomes. And that will be true here as well. What we're proposing isn't radical. It's a very thoughtful and reasoned attempt, like so many others across the country, to make our state just a little more just for some of our most vulnerable citizens while balancing the realities of limited resources. It's really time, and so we enthusiastically seek your support for these long overdue reforms. Thank you.
Thank you, and I especially appreciate your work with the Michigan Guardians Association because I know that they, let's face it, they do a lot of work and they don't even get paid for it, which I know that's something that we are attempting to address through appropriations. And that's probably one of the biggest concerns. And I also just want to make a quick note to the people that are up front here, Mr. Howe, Ms. White, Ms. Luma, and some of the others that I've spoken with. I've heard you. I feel for you, and we are going to try to do everything that we can to make sure that the tragedies that your families have experienced don't affect others. So that is the goal of these bills as we continue to update them. We are working on substitute bills, and thank you for bringing this forward. I do want to know, because one of my questions was, what do other states do? And you noted the licensing and certification. Do other states have anything sort of like their own office of the state guardian or anything remotely close to that? And what other states and what information do you have about them?
Yes, many states actually do. I know Georgia is perhaps the most recent state that I'm aware of that has created it. If you'd like me, I can provide to you after a list of states that do have offices of state guardian. I'll note that many of those offices perform slightly different functions. Some are only there to appoint guardians for people who are indigent. Some are there to make sure that there's a licensing and certification process. So the functions of those offices change, but I'd be delighted to provide you with the list of the states that have created some sort of office of state guardian and some information on what they do.
Okay, thank you. Representative Fink, you have a question?
I do. It is actually somewhat related, Madam Chair. In looking at the Office of State Guardian Bill 5047, I see there's a caseload limit of 30 individuals for professional guardians. I'm not good at math, but my old friend Phil Brown, who used to be our budget director, is, and he's pointed out to me that if there are about 130 professional guardians in the state right now, and there are 15,000 people who are subject to guardianships, then we are about 5,000 guardians short if they can only handle a maximum of 30 each. I understand that part of the idea of the package is to reduce guardianships in total, but I don't think it would be by enough to make those numbers work. So can you shed a little light onto both the math problem and the question of whether, as you look at other states, they've enacted similar caseload limits?
Sure. So the caseload limit is actually higher than that which is recommended by the American Bar Association, which I believe is 20. And many professional guardians also work using a team approach, where it's not simply one person, but a number of folks in that office who are responsible for the operation of the guardianship. I'll mention real quickly, just by way of real life example. I was just speaking to Lisa Lapine, who is a professional guardian at the ARC of Macomb County, and they serve approximately 180 people, and they have a staff of 10 people. I talked to her about this proposal to take her temperature on it to see if it felt realistic. I asked, how many folks in your office would you have licensed under the Office of State Guardian under this proposal? And she said all 10. And I said, okay, does that mean that you would then go on to serve 300 people? Because 30 times 10, I'm not much of a mathematician as a lawyer, but I asked her, would you serve then 300 people up from your 180 that you're currently serving now? And she said, no, I couldn't do that. That wouldn't be appropriate. I would not be able to do that job in an appropriate way. I would continue serving approximately the 180 folks who I serve now. I'll also mention that approximately 2/3 of guardianships are family members who are serving in that role. And again, because of that team approach, just because, Guardianship Inc., which I'm not saying is an actual corporation, I think there might actually be a Guardianship Inc., but if, for example, you have Guardianship LLC or Guardianship, corporation serving, often that is done, like I said, as a team approach, where they're not simply one guardian. They have, maybe a dozen folks working there as guardians. And so if they had those 30 people served across 10 folks, then this is already how many professional guardians operate. And when I referred earlier to, operating in the spirit of the law, that's exactly what I was talking about. Folks are already doing this with a team approach. They already have this staff of folks who are prepared to handle as many people as possible. And so I think this number is very realistic, especially in keeping with the fact that 2/3 of guardianships are already done by family members as well. So we don't want to break the system. We've had very extensive talks with experts across the country on this. We understand the concern on that point. and there was a lot of care in that number. But I also believe that that number may be even increasing in a sub that you're getting as well to address any concerns.
And I'll just say very quickly, I mentioned Georgia as a state that's recently done guardianship reform. I just heard a presentation from them. They are absolutely adamant that they want their caseloads to stay at no more than 25 individuals, and their guardians only do the actual casework, not the fiduciary, not the financial part of it. So just focused on the personal issues for those individuals. They're absolutely adamant they cannot go over 25 people per caseworker, and they prefer to have 20 or fewer. I'll also say, as Attorney General Nessel pointed out last week, many of these proposals and some of the ones that are still in the pipeline will, we hope and trust, significantly reduce the number of guardianships that are necessary. And so we want to save guardians only for those cases where they're absolutely necessary. We hope we will not need guardians for nearly as many people as currently have them. The last thing I wanted to say is there are a number of individuals who won't be contracting with the Office of State Guardian to accept the guardianship for people who are indigent. Those individuals would not be limited. It's only the people who are accepting these contracts, and it's only because we know that if you have a caseload that's higher than whatever number we actually end up on, 30 or whatever's in the sub, we know that you can't do a good job. You can't know that person and make excruciatingly important decisions for them if you have a vast caseload and you wouldn't recognize them in a lineup. So, thank you.
I'll just clarify, you don't if you don't want to take money from the state to do this job, you can serve as many folks as you want. But if you do want to take money from the state, then you would have to abide by those caseloads.
Okay, so while that is helpful, it actually leads me to another math problem, which I think maybe you and I batted back and forth a couple weeks ago, which is if it's $83 a month and you want people to serve 20 to 30 or whatever, I mean, if it's like 20, forgive me for trying to do this in public, but if it's 20 times 83, I think that's $1,660 a month, which comes to like less than $20,000 a year. So what are we doing to, I mean, why would anybody want this work?
So I think that's a fair question. It's hard work and it doesn't pay well. Part of it is kind of underwritten by the cases that do pay well, with folks who do have means, where there are conservatorships where you can actually be paid by that individual out of their estate. I also think it's another reason why we absolutely have got to have this Office of the State Guardian, because right now those types of cases for folks who are indigent, particularly folks who are living in the community, those guardians are not getting paid at all. They're taking on those cases because they're devoted to the cause, because the court asked them to do that, because there is a need. And by creating an Office of the State Guardian, which would give a payment system to those types of cases, I think is absolutely crucial, because there's a significant number of pro bono cases out there, and this would actually take some of the financial sting out of that. Particularly when I talk to folks who serve maybe younger folks with developmental disabilities who are out in the community who don't want to be in a nursing home getting paid that $83 a month. This is going to give folks a stream of payment there. And it doesn't have to be $83. We can increase that to a more appropriate amount through appropriation. So I hope that answers your question. I can talk at length, so I'm happy to have other conversations.
We're not going to let you talk at length anymore. I'm sorry. Okay, I have to say goodbye for now. Okay. So,
Thank you very much.
Okay. Next we have Sally, is it Pung from the Michigan Lawn Care Ombudsman Program. Thank you for joining us.
Thank you. Good morning, Chair Breen and members of the committee. I'm Sally Pung, the State Long-Term Care Ombudsman and also a member of the Elder Abuse Task Force. So the Michigan Long-Term Care Ombudsman Program, which I direct, seeks to improve the quality of care and quality of life for residents who live in nursing homes, homes for the aged, and adult foster care homes across the state. I am pleased to be here today because many of the residents we serve are subject to guardianship. Guardians are often granted the power and responsibility to make all personal, medical, and financial decisions for another person. Some residents report being well served by their guardians, which we are very grateful for. But many residents are not as fortunate, and some report that they have never met their guardian. I would like to just share a few examples with you today of issues reported to the Ombudsman Program related to guardianship petitions. So we had several residents facing guardianship petition because they had an outstanding debt with the nursing home. Our ombudsman intervened and was able to help resolve all the cases without a single guardianship petition being filed. And my point is, guardianship should not be used for the mere purpose of debt collection. and the New York legislature is considering legislation that would bar a nursing home from partitioning for guardianship purely to collect debt. Another concern is when providers have indicated they anticipate the person's capacity might diminish in the future, prompting the petition for guardianship. No person with capacity should be subject to a guardianship petition simply because they may have diminished capacity in the future. We all have that in our future. How frightening for a fully capable person to face guardianship, which too often results in a devastating loss of autonomy, humiliation, despair, and even the negative consequences to your physical and emotional and mental health. And lastly, we know of guardianship petitions being sought as a resolution to residents' poor decision-making. And that's very subjective, the poor decision-making. Each of us has the right to take risks and make poor decisions. Guardianship should only be based on the individual's capacity and not the poor decisions that they might be making for themselves. So I'd like to speak about the resident's experience under a guardianship. So I'd like you to take a moment to live in their shoes. So imagine people saying they are not their own person anymore when they're referring to you. This is the label that comes with having a guardian if you live in long-term care. You're not your own person anymore. It's devastating. Hearing, you can't live in the community again. This is now your home. And oftentimes guardians may insist on facility placement because it's too time-consuming and more expensive to manage a person in the community. It speaks to some of the concerns that Nicole and Allison addressed. Or hearing you are no longer allowed to make decisions about simple daily tasks. Imagine not being allowed to go outside to enjoy the fresh air and the sunshine, not being able to see your family members or longtime friends, not going to church service where you attended since you were a child, or not being allowed to enjoy a piece of cake at the monthly birthday celebration. These are all things that have been reported to us, where a guardian blocked a resident's decisions on those minor items in life. So the list of restrictions go on, yet the intent of a guardian is to not be restrictive, but to be supportive of the person subject to the guardianship. Because ombudsmen know the incredible difference it makes to residents to have a capable, caring, and knowledgeable guardian, and to only have a guardian appointed when a person's decision capacity is diminished, I'm happy to support the legislative package because I know we can do better. Thank you.
Thank you for that testimony. When in my prior life, I would take calls from nursing homes, and the simplest of things that people were complaining about that they weren't allowed to do because somebody else determined they were not able to make that decision. Even that example of having birthday cake, it's absurd. So I appreciate your testimony. Are there any questions? No? Thank you. Also, you noted the nursing homes that would petition for guardianship because of a debt. I'd like to further discuss that, make sure that we have the appropriate guardrails in. Okay? Thank you so much.
Thank you.
We have Nathan Pavarsky on Zoom.
Good morning.
Thank you for joining us. We've got about 5 minutes for you.
Very good. Thank you, Chair Breen, and thank you, members. I've had the honor of testifying before you before, but it was on behalf of the probate and estate planning section of the bar. Today, I'm testifying in my capacity as a private practice attorney, as a citizen, and as a member of the task force. My testimony will focus on the procedural aspects of the bills. We've talked a lot about what happens and what a guardian can and can't do after an appointment. My experience is informed by my work as a probate attorney. I'm a private practice attorney, but I've also had the honor of serving on a contractual basis under 2 attorneys general. I've served as a special assistant attorney general for the Adult Protective Services Division of the DHS since 2013. In my private and contractual roles, I've been involved in hundreds of guardianship proceedings spread across dozens of counties. I've personally participated in contested guardianship matters on behalf of the state in at least 16 counties, and I've participated in hundreds of contested probate matters over various kinds in over 30 counties. I've represented petitioners, respondents, and family members, and I've occasionally served as the court-appointed guardian ad litem. And in my work, I've seen somewhere between 200 and 300 reports of guardians ad litem to the court, and a similar number of reports of physician or health professional. This is a little bit unusual in that most probate attorneys have a practice that's a little bit more geographically constrained, but I happen to live and work in Northwest Lower Michigan with my main office based out of Cadillac. So this is kind of a unique perspective that I brought and that motivated me, frankly, to volunteer for the Elder Abuse Task Force. I can tell you that in my personal experience being involved with these proceedings, I have regularly encountered the following. The first is unpredictable, non-uniform procedures for emergency guardianships. In some counties, it's troublingly easy to get a guardian appointed, often without the court taking really any testimony or any testimony on an open record. In others, it's virtually impossible to get a guardian appointed on an emergency basis. The only uniform characterization I can give regarding emergency guardianship procedure across the 30 counties I've practiced in is that in each county, there's just really only a handful of people who know the unwritten rules of how it works there. The second thing I've observed is that guardians ad litem are often underpaid and are not subject to demanding enough requirements to give proper process and good information to the court. I regularly have seen guardians ad litem meeting with interested persons for mere minutes or not at all, or minutes before the hearing. I've seen the guardian ad litem misused in contested matters. Their reports don't say how long, when, or who was present when they gathered information. Third, I've seen courts relying on incomplete and sometimes very unreliable medical reports. Some of these reports are so hastily and poorly put together that the court and the parties can't even be sure of the name of the medical professional because it's unlegible. These reports routinely fail to include med lists, which are crucial to understanding a person's level of function. Taken together between the deficient guardian ad litem and medical reports, courts are regularly relying on reports that are based on a trivial amount of time invested in understanding a vulnerable person's situation and that give appallingly little consideration to areas of positive function for an individual or ways that you can empower a person to exercise their autonomy and dignity. Finally, I've observed an unhealthy and largely unspoken codependency between probate courts and local professional guardians and conservators. There seems to be often an uneasy, unspoken agreement that professionals accept no payment in some cases in return for the opportunity to receive particularly generous pay in cases involving persons of means. Taken as a whole, these bills solve a good deal of these problems. They're a down payment on what is necessary to recognize the dignity and civil rights of our most vulnerable Michiganders. I wholeheartedly support these bills. I'll also note that the Office of State Guardian will go a long way toward providing proper resourcing and uniformity in practice for guardians who are doing important work for our most vulnerable Michiganders. Thank you so much.
Thank you. Do we have any questions for the witness? No, thank you again for your testimony. I appreciate it. I'd like to call up Aaron Van Leggenveld and Scott Teeter from the Attorney General's office. And I thank you for your testimony last week, but we do have some additional questions regarding specifically the Office of the State Guardian. And my question to you is, what more can you tell us about the mechanics of it, the cost, proposed parameters, staffing, things of that nature?
Sure. If I can circle back just to address Representative Fink's question, and that is, I did sort of the reverse math. When we originally put together the draft of this, we had worked with MGA and said, okay, we need a cap. You can't represent hundreds of people and do that well. What would be a reasonable cap? It wasn't 30. That was not our original proposal. It was 36. And so that we've already corrected with the drafter on this next round that comes back. And they had agreed to that number. Again, the business model that Nicole Shannon had talked about, which would be an umbrella where there would be designated court-appointed guardians and for indigent clients would handle one part of the practice, and then private pay individuals would be handled by other guardians. And I ran the math. The $83, which is kind of the number that gets kicked around all the time, is what Medicaid would pay if you put that person into a nursing home. There's no magic to that number. And so the idea that, you know, the Office of State Guardian would have to be at $83 so that that would cap at, even at $35,856 a year, that's not necessarily our recommendation. The other thing I think is important to consider is we have set that implementation date out 2 years for the specific purpose of recruiting, training, and getting certified more guardians than we have today. And so the combination is, you know, with the powers of attorney bill, the surrogate consent bill, reduce the number of guardians and then up the number of folks needing guardians, excuse me, and then up the number of guardians at the same time so that when we hit that 2-year mark, we'll be prepared to handle that new caseload number. In terms of what's it look like and what's it cost, the bill sets up the Office of State Guardian, and we're going to need an executive director. There'll be a deputy director, there'll be an analyst, and there'll be some additional support staff. I've put the numbers together, and again, these are really rough estimates, but that would take about $750,000 a year. In addition to that, we've designed the investigative unit in the Office of Attorney General based on the investigative unit that my division has, and that is it would require one civil attorney that would be in a position to actually go into court and present these cases if we want a guardian removed, or if we want them removed from all cases, or if we want some other relief. And in addition to that, a criminal prosecutor, because again, with the increased caseload, right now, my division handles those investigations, but we only handle $100,000 and up. We have 4 investigators who work on it all the time, and if you called me today, it would be a year and 9 months before I could have that case assigned to an active investigation. So,
Quick question there. Yes. You say right now your office only handles cases where there's allegations of $100,000 or more.
Yes.
And about how many people or cases fall below that threshold?
I get calls every week with cases that fall below that threshold.
And what happens to them if you don't take them up?
That's the difficult part. We try to work with local law enforcement and with local prosecutors to ask them to pick up those cases, because otherwise we would be out 3 and 4 years. And many of the times the victim of those crimes, as an elder adult, they won't live through the time it takes us to start the investigation.
Okay, thank you.
So that's why we really need a dedicated unit to respond to the allegations of the just involved guardians, and that's covered by that OSG. Is that when OSG thinks something needs investigated, they refer it to our office. We do the assignment and the investigation. So when I take all of that together, what it looks like is this: MGA doesn't represent all wards. Obviously, there's 33,000 in the state of Michigan, and not all professional guardians are members of MGA. We had asked MGA over a 4-year period, probably a dozen times, to give us actual numbers on their caseload. That never happened. But I was able to sort of reverse engineer the math. 4 years ago, they asked for, and they actually got into the House version of the budget, $4.3 million. And so if you, it was later canceled when the governor line itemed out a bunch of parts of the budget that died in that process. They were asking for that $83 a month per indigent ward. And because again, that's comparable what they get paid if they put the ward in a nursing home. They've always maintained that 43 to 44% of their caseload is indigent clients not funded by anybody. So if you reverse the math, the 4.3 million divided by 83 divided by 12 months equals 4,300 indigent wards, which would put their total caseload at about 10,000 wards out of the 33,000. The others are either represented by people who are not members of MGA, or the vast majority are family members who are guardians for family members. So if we take all that, put all that together, this is what the ask looks like, because there's couple variables that I can't give you, and that is ultimately when we see the effect of some of these reforms, what's that going to do to the caseload? It's obviously not going to drop it in half. That's not realistic, but I think we can certainly slow the increase that's going to happen between now and 2030, and also creates the opportunity to start, creating those off-ramps. Total, and again, there's a couple proposals that we've looked at with other states. I'm an advocate of, I think it's got to be more than $83 a month.
83 is the total.
$83 a month. 83 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 a month. under certain circumstances, and that is when a guardian first gets appointed, there's a lot of work that has to be done at the beginning. Sometimes they'll be called in and this person's living in absolutely deplorable conditions, and they need immediate attention and a lot of it. So front load that amount. Washington State does that. It's $240 a month for the first 6 months until they get it under control, get it stabilize the housing, and then go into kind of a maintenance mode. I could see us looking at the same thing under the Office of State Guardian. So I think there's some proposals out there that we can sort of, borrow from the best of what's happening across the country. And again, those numbers have not been set down in stone, but even if we took where MGA was, plus the other things that we've talked about, plus put in some extra for the, perhaps a higher rate, that puts us at a total ask of about $10 million. That sounds like a lot of money. Let me give you the comparison. When we talked about this last week, MIDC was our model. And
For the people who don't know the acronyms.
Yes, Michigan Indigent Defense Commission. Our state made a decision, and I think a good one, that the civil rights of people who are accused of a crime were not being adequately protected. So we increased the funding and increased the network that provides representation for those individuals. And in 2019, that funding was $87 million. In 2023, it's $172 million. The analogy is we're talking about these folks' civil rights also. And it's somebody to make sure that they're properly cared for month to month. Not just for a criminal case, not because they're accused of doing anything wrong, but because they need our help. That's what we're asking.
We have scant time available right now, but my next question is, what about the lay guardians, the family members? I would hope the Office of the State Guardian would provide some support for these folks who suddenly have to not only care for their own selves or their own families, but they are now taking care of mom and dad or their spouse, and that can be incredibly overwhelming. What do you envision for support as far as the lay guardians?
Great question. First thing is, certification is not required for the lay guardian who's taking care of their family members. There's been some confusion about that. That's absolutely clear. It's never been our intention to require everybody. If I wanted to be the guardian for my mom and dad, I don't have to go to a course and be certified and all of that. But the OSG will be in a position to prepare training material and information, and we would put together a video to go, okay, there are some things that you need to know. Because if you're going to take this responsibility on, then you're going to be responsible for the care, for supervision, for perhaps filing the forms, and we can show you how to go through that. I think we serve as a resource so that anybody could pick them up and go, okay, I don't know how to do that. I'm not a lawyer. I don't have a lawyer. I don't have the money for a lawyer. How do I take care of my mom and dad? What forms do I have to fill out? Where's the accounting and an inventory? That's all stuff that we can put together, and then they have one place to go. And some probate courts do a really good job of this. You can find it in their lobby. Some not so much. And so they can pick up the phone or go to the website that we're going to create and go, okay, tell me how to navigate the system that I just got dropped into.
Okay, I'm going to turn into a pumpkin in a minute if I don't get out of here. Does anybody have any questions, noting we are going to continue these discussions next week? Representative Wozniak, our local expert.
Thank you. Thank you, Mr. Teeter, for your testimony. Do you see a way that we can proliferate the use of powers of attorney and patient advocates rather than going into the court system and using guardianships and conservatorships? And I think there's a problem out there in the public that when we mention nursing homes or hospitals, they tell the person, go get a guardianship. Yep. And I think that's part of it.
Yeah, you are 100% correct. In fact, I'm testifying tomorrow in support of the power of attorney bills that the House passed by an overwhelming, it was 100 to 4 or something. It was, I mean, that's a no-brainer. We're counting on that. I'm not just hoping. And the reason being is because all the things we talked about last week about maintaining autonomy and the decision-making and recognizing my choices, powers of attorney do exactly that. So I pick the person who's going to make the decisions when I can't. Not the court, not some stranger. It's my person. And so those bills are critical to this whole part. We're going, the best way to avoid the Guardian superhighway is don't get on it.
It's been my advice to a lot of clients. Don't get involved with that.
Well, and those bills actually not only do the, let's make it as easy as you can to complete one,
Right.
but let's make sure that everybody else starts honoring them. Because I've heard back from banks and from credit unions where people have gone in and said, hey, I'm power of attorney and all that. No, you need a guardianship and a conservatorship. That's not the law. But we need to clarify the law so that if that happens to me, I get to go to court and you're going to pay my attorney fee for not taking it.
Yeah. So you and I had a conversation last week about giving direction to the public if they do get appointed as a guardian or conservator and making sure that they understand what they're getting into.
Yes.
And they don't have that right now.
No, and in fact, in that power of attorney statute, it actually has an acknowledgement of the duties and responsibilities, because even as a power of attorney, that's a big deal. And I need to know, when I take that, that's a fiduciary duty. I have to track all of the receipts, the disbursements. Don't do this lightly. This is a big deal. Well, so is a guardian. And so I think we need to do a better job up front going, I think it's great that you want to. Let's be realistic. Can you? And if you can't, maybe we should help you find somebody else.
Thanks for your great work on this.
I appreciate it.
All right. On that note, we're going to close out testimony, and I appreciate everything that you've done, and I know we're going to have some continued discussions for a little bit. Thank you, gentlemen.
Thank you.
I'm going to read in some cards, and then I got a scoop. See, supporting the bills, not wishing to speak, Matt Phelan from the Alzheimer's Association. Supporting the bills, not wishing to speak, supporting the bills with amendment, Alex, just for 4910 and 5047, Alex Morris from the Bankers. Neutral on the bills, wishing to speak. Unfortunately, we don't have time. Cynthia Mifsud. Happy to talk with you offline. Neutral on the bills, wishing to speak, Lori Luoma. Again, we have spoken. Jody White, wishing to speak, neutral on the bills. Thank you. And Sean Bennett, supporting the bills with amendments for 4911, wishing to speak. All these will be recorded in the minutes. I will do, another stack. Genevieve Marnin from Right to Life of Michigan, neutral on the bills, wishing to speak. Tom Howe, opposing the bills, wishing to speak. Mr. Howe, I'm afraid we can't get to you today. And Pam Howe, wishing to speak, opposing the bills. But hopefully we can get there. And I appreciate your attendance. I appreciate your patience. I appreciate everybody's patience as we try to make some changes for the betterment of our elder community. All right. And seeing no further business before the committee, we are adjourned.